In the 1974 instance of U.S. v. Nixon, the high trial solidly discarded execution benefit in a governing how caused the peak of the Watergate fracas. The top trial signed how this basic demands of due trial of act as so as the particular requirement for testimony in a anticipated penal test overrode the CEO's statement how he had a constitution order to hold communication individual. How instance implicated a summons for the CEO's oblong office space tapes, not for a private interviewing. In individual probable blueprints for a CEO searching to avoid trial-related transactions, CEO draft Clinton in the 1990s was exposed to a civilian litigation or, individually, serviced in a summons to witness. This summons was closed while Clinton coordinated to witness willingly. Though it is not a routine incident, precedents for centuries include desired to oppose lathe above material to courts. In an 1807 instance the high trial quoted while it controlled versus Nixon and Clinton, CEO Thomas Jefferson tested to conceal private documents of the betrayal test of his ex-defect CEO Aaron Agnale. The contemporary test for execution benefit, as the complaint is now named, is U.S. v. Nixon. The benefit arises of the division of powers amongst the three-branch and the concept how execution communication, such as war and tactful secrets, should stay sensitive. How 1974 Constitution showdown began following a great jury trial convicted 7 aides and advisors to CEO Richard Nixon for plot, obstacle of judiciary, and some infringement associated to the breakdown in of the more democratic domestic board staff at the Watergate House in 1972. The great jury trial mentioned Nixon as an unindicted company conspirator. The Watergate specific attorney derived a summons how aimed Nixon to rotate above ribbon recordings and documents regarding to conversations in aides. Nixon rejected, quoting a wide complaint of benefit to hold communication individual, and the instance rapidly escalated to the high trial, that heard the controversy on an expedited plan in July 1974. In the unanimous governing spelled by head judiciary Warren Hamburger, the trial recognized the CEO's requirement to hold communication sensitive but told it was eclipsed by the interests of the court trial. Out of accessing to particular facts, Hamburger wrote, a penal proceedings may be completely disappointed. The CEO's wide concern in privacy of communication will not be vitiated by disclosing of a bounded quantity of conversations previously shown to include several bearings on the anticipated penal cases. The July 24 judgment constrained Nixon to abandon the incriminating tapes, and he obedient of the chairmanship on August 9, 1974. This a main instance about a CEO who tested to escape creature stretched in a court trial is the 1997 instance of Clinton v. Jones. In how controversy, the high trial controlled Clinton could not apply President immune to delay a civilian litigation by Paula Jones, who told he had sexually troubled her while he was governor of Arkansas. As they reasoned for immune, Clinton's lawyers told the CEO's participation in the civilian instance would divert of execution branch's industry. The high trial solidly controlled for Jones, quoting U.S. v. Nixon and some cases. The trial told how it did not weight Clinton's participation in the instance to be diverting and marked the common concept how presidents can be object to court transactions while relevant. The next year freelance advisor Kenneth Starr derived a summons to force Clinton's evidence in a individual question comprising Monica Lewinsky, a ex-White's building internee in whom Clinton had had a relation. While Clinton coordinated to the interviewing, Starr withdrew the summons.